is that cat?
Archer. You just gonna stare at me? Oh.
I am walrus. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Good to have you guys back here on this fabulous hump day. If you missed the premiere last night, our Nevada judges posted the latest hearing from Mr. Roger Hillygus. You can't recall who that is. He's the man who kidnapped his mother or grandmother. I keep forgetting which one. Took her from Nevada to California, where they ended up getting hooked up by the police, and both he and a former sheriff are being charged with this. While the former sheriff is kind of loony, kind of off, Mr. Hillygus is definitely gone full sovereign citizen, and apparently he made that abundantly clear in this latest hearing, which is I believe the point of the I watched most of it, but the point of the hearing was to determine whether or not he's competent to stand trial, as well as being able to conduct his own defense. Because I believe his current attorney would end up becoming standby counsel. So it's going to be a while. There are a lot of buzzwords in place. That's why we are going to be playing some bingo along with it. This is just for fun. Because I don't have much funds. For those of you who are wondering, Archer had his surgery this morning. He's fine. He's back home. Mostly awake. Kind of groggy, but he was able to eat something. I got some medication for him. And I'll be taking him back to the vet in 2 weeks for a checkup. But yeah, he's doing okay. It's just I got a lot of streams to help with the offset the funds, because my headset broke also. So my headset broke. My work shoes are breaking. You know, it's when it rains it pours. You know what I mean? So I got a lot of repairs to do. Yeah, so we're going to get it started. I believe the first couple of minutes are a little bit boring, so I think we can skip it. It's an hour and 15 minutes long. I think we'll be able to get through it, though, in one sitting. So, all right, without further ado, as always, guys, the link to the bingo cards is the pinned message up top. And with that, let's go.
To object to Mr. Stady's referencing me as a pro per, self-represented. I present myself as the living man. I do not represent the fiction. I am not a fiction. I'm not a corpse. I'm not a transmitting utility. I am the living man. I am not pro per, pro se. I do not represent myself. I present myself as a living man. So I object to the use of the word pro per, pro se, self-represented litigant. That is not who I am. Thank you.
It hoped.
I believe I think most of this is the indication that he wants to be standby counsel. Whether or not he can be Whether or not he's competent, they mentioned that he had an accident, I guess a head injury from about 10 years ago, but doesn't seem to be that is affecting his cognitive abilities.
Mr. Hillygus' ability to understand what's happening and appreciate the court process. The court is aware that willful behavior, even behavior that might be different, unusual, a minority view. That is not the legal equivalent of a mental illness.
Who is coughing?
We're talking cognitive disorder, mental illness, things that would impair psychiatric symptoms that would impair Mr. Hillygus' ability to proceed to adjudication, not beliefs, a belief system that might just be different. Dr. Nicole Mack, board-certified forensic psychologist, came to the conclusion that notwithstanding the inability to fully examine Mr. Hillygus, she finds that he is competent to proceed to adjudication. No history of treatment for mental illness or cognitive disorder. Seemed to understand what he was asking her to do and respond to. She believed that whatever he has going on is a result of willful behavior choices and not something that would impair his ability to proceed to adjudication. We have Dr. Susan Waring, whose report not nearly as comprehensive, but her default position was because there's a presumption of competency and because Mr. Hillygus did not fully engage, she finds that Mr. Hillygus is competent to proceed to adjudication. At the last hearing, we did listen to some of the jail calls between Mr. Hillygus and third parties, which seemed to suggest to the court that Mr. Hillygus was well aware of where he was, with whom he was speaking, what he was speaking about, and had an appreciation for his situation and a degree of appreciation for the court process. I believe I indicated at that hearing that the court would anticipate hearing perhaps more fully the discussion he had with those persons or others for purposes of today's hearing. The court notes that Mr. Hillygus responded to the court's questions at the last hearing about where he's domiciled, whether he has a place to go in Washoe County, things like that, and he did so in a relatively coherent, straightforward manner. Then he makes statements like the one he made when the court took the bench, that we're all under investigation and we're on notice. And the question then would become, what does the court make of that in reviewing NRS 178-400 competency? What does that show about somebody's ability to aid and assist in their own defense within a rational degree of understanding of what they're up against? The court has already made clear during the Ferretta hearing that Mr. Hillygus is facing multiple serious felony charges against a very experienced prosecutor with a lot of resources.
Hey, Dummy Kruger, I see you in the chat, man.
So, but I'm going to make good on what I said before. I want to make a decision on this today. So
everybody go check out Dummy Kruger.
With the defense, and Mr. Prasad, again, your office was appointed to assist with the competency proceeding process. A little different than close cousin to standby counsel, but as you noted in your recent filing.
Hello, Jester.
So I'm going to hear from you first if you'd like.
Oh my god. Oh my god. Oh my god. Thank you, Anonymous, for the $500 tip. What the hell is wrong with you? Says take care of your kitties. Right. Thank you, whoever you are. That's really sort of you to do, but thank you. Wow. I was not expecting that at all, actually. Whoever you are, thank you, Anonymous. Hey, Woodwork, thank you for the $6.90. I appreciate it, Andy. It really will help. But I'll be using that care credit that you guys had mentioned to me before. For the upcoming stuff. All right, I want to keep on pausing, but thank you so much, both of you, for your generosity.
The court hear from any witnesses. I will if you want.
They're not. No, anything. Our union, anything over $100 will now get you the jump scare.
The court hear from any recordings. I will make argument. If you'd like the court hear from Mr. Hillygus directly, I will. But at the end of the day, what is your view of whether your client is competent to proceed to adjudication, please?
Thank you, Your Honor. At this time, I was not planning on calling any witnesses or providing any additional information to the court. I reviewed both of the evaluations provided, and I don't see a reason to reverse them. I understand that Mr. Hillygus was not the active participant in the evaluations the court would want to see, but I do know that in both evaluations, I think some extra work was done. It appears Dr. Lauren's evaluation included a 15-minute observation period of Mr. Hillygus.
True.
As well as, I believe, some review of Methodist.
No way, Methodist Dave.
And it appears Dr. Mack's evaluation that they had long conversations with staff at the jail, as well as reviewing documents to get a better understanding and idea of Mr. Hillygus. So I think on those, I would note that these are not just, well, we have no choice but to find him competent because he didn't meet with us, but I think there's some deeper investigative work involved that helps inform their conclusions. I think I also have no plans.
God, I thought I turned that off. Oh God, now that everybody knows flashbang is turned on, I need to go turn it off. Oh my God, I thought I kept it off. Stop it, all of you.
Flashbang. Throwing flashbang.
Oh my God. Okay, I turned it off.
Interactions with Mr. Hillygus.
What happens when you spam?
I have not. I do not have a reason to believe he's incompetent at this time. I obviously was not present when competency proceedings were initiated. I don't know if I would have initiated them based on my interactions. Granted, these have been only over the last couple months. And so I think, given the totality of all that, the two reports, my interactions with Mr. Hillygus, I have no reason to reverse the findings. I don't plan on reversing them at this time.
One moment, Mr. Hillygus. Does it concern the defense that he apparently injured himself falling off a ladder or a roof in 2019, and what effect, if any, that might have on his cognitive abilities?
I think the effect on his cognitive abilities would already be present, right? This was not a recent fall that happened at the jail that might be now creating new effects. So I think our interactions with him are inclusive of any effects that fall is having on his cognitive abilities. And as I indicated to the court, based on my interactions with him, I don't interact with him one way and then read these and think that doesn't
Alright.
make any sense. I need to traverse these. There have been cases where where I receive competency findings and I don't see how that came about based on my interactions with my client. I think in this case, I don't feel that way. I think the conclusions, I don't see a reason to traverse. And again, the evaluators who I do think as professionals get a little bit of deference in the way they evaluate the conclusions they come to, they've done the extra legwork. They've done an observation period, they've spoken to others, and I didn't see anything in their reports that would set up alarm bells.
Okay, so it sounds like, hey, Brad, hope you're doing well out there. Staying cool. I'm trying. Sounds like the attorney's also trying to say that he's competent to stand trial. But, obviously his defense counsel's hands are tied,
Mr. Hillygus, you want to address the court? Go ahead, sir.
No, Jasper, they're not at trial. This is, I believe this is a hearing in part to, for the judge to ascertain competency. That's a pre-trial hearing.
I object to the hearing on multiple reasons. I have not been provided any of the documents that we're talking about today, so I've not seen any of that, so I've not been properly noticed or served. There are jurisdictional challenges that have been placed before you,
Jurisdiction?
and they have not been responded to with a finding of fact or conclusion of law. So I therefore continue to challenge your jurisdiction in this case. I have not seen a finding of fact or conclusion of law. We should use your jurisdiction over personally. Because you have stipulated by silence that I am one of the people, I am a true man, I am a fiction.
I shouldn't be Comcasted. Audio's glitching? Uh-oh. I shouldn't be glitching, guys. It sounds fine to me. Wait, I sound bad? Audio of the clip. Try refreshing. I don't know why the court audio would be bad, though.
I'm not
It's just a clip. It's just the clip.
It shouldn't be. The clip sounds fine to me. That's what's weird.
It was just a little piece. It was just a little piece.
Oh.
I am a natural professional living man.
Did I ever have natural living man? I feel like the only ones who say that has been like Ernie, the Montana living man.
And that is a reason why you lack personal jurisdiction, and you do not lack subject matter jurisdiction over this case either. Because there is no victim in this case, there is no injured party, there is no...
Okay, so the audio is incomprehensible now? Oh boy.
Okay, it's doing it again. It sounds really bad now.
All right. I don't know why it's doing that. Let me, do I have a copy here? All right, let me see what stopped at 24 minutes, 7 seconds. Let's, restart it. All right, let's try it again. Let me know.
There is no probable cause. This case all started, and by the way, there is a FOIA request that is being looked into, the federal government is looking into why I was arrested in California, in LA, without a warrant. That there was a warrant issued in Nevada based on no probable cause, based on a falsified document by the officer who investigated this, Allison Jenkins. And they also did an illegal track and trace of my cell phone. And the same thing happened in Missouri. It was an illegal search and seizure. And the Nevada Supreme Court recently in Mack, in the case of Mack back in December, ruled that anybody that does an illegal search and seizure loses immunity if they violate your constitutional.
I think he did actually say special appearance, Goddess. I think he did. So we're gonna count that.
Rights. Just about every one of my constitutional rights, from the First Amendment through the 10th, minus the second and maybe the third, but the 4th, 5th, 6th, 7th, and 8th, and 9th, have all been violated by this court and by the prosecutor.
Let me ask you a question.
So the
How-
FOIA
how-
is
how
looking
does-
into.
Please stop just for a moment. We're just, at this point,
Yeah.
we're talking competency to proceed to adjudication.
Okay.
And you heard some of my comments about the fall you had in either off the ladder or roof in 2019, the injuries in 2011. The court wants to make sure that whatever happened to you there is not going to affect you in such a way that you won't understand what you're doing and within a rational degree of understanding, appreciate the court process, even if you disagree with it. File motions, make arguments like this. Can you explain to us at all whether that's something that is a challenge to you, has harmed you, or you think you're good?
I don't know where the court discovered this information, but I have not consented to any of my private confidential health care information, HIPAA, that's Health Insurance Portability and Privacy Act. It's been violated by NAFCare. Multiple evaluators have violated my HIPAA rights. Those are federal rights that I have to my confidentiality of my health care records.
Well, is your response, Judge? I'm not going to answer that because I don't think you have the right to ask me.
I object to the evaluations because Dr. Loring filed a false report.
So if you don't know, there are HIPAA privacy rule exceptions. Those would be public health and emergencies affecting the life and safety of the public, research, judicial and administrative proceedings, law enforcement, informing next of kin, body identification, directories, workers' compensation, medical examiner. But the big one is judicial and administrative proceedings.
We did not meet for 15 minutes. She discovered information that I had specifically requested the Washington County Detention Facility and their subcontractor, NAFCare, not to release any of my confidential private healthcare information. I was told by the NAFCare nurse that took me in an intake that everything that I told her would be kept confidential.
Well, for purposes of a competency hearing, the court needs to make an informed decision, and the evaluators need to make an informed decision. And they look at your physical health, they look at your mental health. You understand that, don't you?
No, the reason for the competency evaluation is I challenged your jurisdiction
He doesn't stand under, Judge.
to cover yourself for the jurisdictional challenges. You didn't like what I was saying about challenging your jurisdiction. You decided that I was incompetent. So you issued.
I never decided you were incompetent. I said the court had concerns about your competency to proceed to adjudication.
I responded to that order on February 9th.
Hey, Carl.
And I explained that I did not consent to meet with Dr. Deborah Fletcher, I believe her name is, or Debbie Fletcher, or Amy Patterson. And I also responded on June 30th and August 11th with what's called a writ of quorum nobis, and it's recognized in the Nevada Supreme Court as a writ of error. And I filed that. You still have not responded to those writs, those 3 writs of error, challenging your jurisdiction and explaining to you my status and standing. I stand on the Constitution. I stand on the Declaration of Independence. I stand on the Articles of Confederation. I stand on the...
Ooh, that's a rare one. If you got Articles of Confederation, I think I still have it in this list, but that's a rare one.
The Bible, and I stand on the Federalist Papers. And my standing is one of the people. And you have not responded to this jurisdictional challenge, and I've provided a document to Krishna Prasad, and I asked him to file that. I asked him to mail it to my residence. He failed on both of those counts, and he told me today that he still has the documents that I asked him to file, challenging your jurisdiction. So I'm asking for a final effect and conclusion of law that you have jurisdiction over me. You're a corporation. You're a for-profit corporation with a Dun & Bradstreet number.
Nevada Judiciary is a for-profit corporation with a Dun & Bradstreet number. I feel like I need to have a stream to talk about Dun & Bradstreet. A lot of sovereign citizens and a lot of gurus love to cite the fact that a lot of public institutions have a Dun & Bradstreet number. I really gotta like dedicate like a stream for that.
I do not consent to this corporation, and I do not consent to this hearing. I'm being unlawfully detained and held. I have not committed a crime. There are no victims in this case. There are no injured parties.
No injured party.
I have not committed any crimes. I'm being held against my free will. I have not consented to the corporation of the Washoe County Detention Facility or the Washoe County Sheriff's Office. I do not consent to being taken against my rights in Missouri without a proper search warrant or a valid arrest warrant. The two magistrates in Missouri dismissed this case for lack of jurisdiction. They understood that they lacked jurisdiction over me. There was no injured party, and I was still unlawfully detained. The Nevada legislature is looking into this case. The United States Senate is looking into this case.
Are they? Are they? Is the Nevada legislature looking into the case, or the Senate looking into the case, or did you just send them a bunch of paperwork? I'm feeling that it's probably a bunch of paperwork.
They're considering impeachment proceedings.
Against who?
And you've been placed on notice that I'm proceeding in the common law, and I believe you've been given 2.
We cool? Yeah, we're cool. Brad? I mean, well, I'm not cool right now. I got my fan going. I'm still not cool. I was asking if you guys were staying cool, considering y'all are in Phoenix.
Notices, and you have not responded. So your silence equates to your stipulation that I am one of the people.
Did he say fictitious? If he actually said fictitious, then I'll count that as legal fiction. I'll count that. Dracandros, thank you for the $2 Australian.
Proceeding under the common law, and that there is
Common
no
law.
party in this case. This case must be dismissed.
Common law.
I asked to be released immediately. I am being detained against my free will. I have not committed a crime.
Mr. Staken.
No, I'm not cool at all.
I think it's helpful to return to the statutory framework.
I'm kind of a loser.
Courts shall receive the reports after, which of course.
Exactly, pure chaos, exactly.
Allow the parties an opportunity to traverse the findings. Mr. Prasad does not wish to do that. I do not wish to do that either. I mean, because my reasons are the reasons I've always stated, which is
Nah, that doesn't count, goddess.
Legal sounding gobbledygook, like sort of politically, political views,
Gobbledygook.
shielded in legal sounding language. The defendant is competent. Mr. Prasad, I think it's quite telling, states that nothing he has seen in his the current limited representation would contravene what the findings ought to be. He does not believe that the defendant is incompetent. The question of the court called it a fairly significant fall. I think we don't have any evidence in the record for that. Right? That's self-reported that he fell. Equally, I would point to suspicious as the use of the wheelchair. Right? Every time he's out of custody, every time he's driving, no wheelchair, and here we have sort of this political and sort of sympathy engendering use of a.
Well, the reason I brought it up today preliminarily was twofold. One, to let you know if the court does adjudicate Mr. Hillygus competent to proceed, then before he comes into trial with a wheelchair, there's going to be a hearing on medical necessity. The second reason is that, you know, if there were concerns about his physical well-being and impact on cognitive abilities, if somebody's showing up in a wheelchair, that makes the court curious what's going on with this person. But he hasn't been in a wheelchair the last few times. He seems vigorous and strong, articulate. And so the question is what he's doing, is it rational? Is it rational? Does he have rational understanding of what's happening here? Your view is it does.
Yeah.
Because let's all agree on something. If the two evaluators come back with the opinion, which they did, that he's competent to proceed to adjudication, that is certainly, can be persuasive to the court. That can be extremely informative
Hey, Jennifer, thank you for the gifted membership.
to the court. It's not
Thank
binding
you,
on the court.
Jennifer.
It's not binding. There's no shall, nor should there be, because it takes out the judicial role to make a fair and impartial determination. But you're saying both, they came in, they both said competent, and you should exercise your discretion, Judge, not to yourself traverse them based on what we have here, right?
Yes, and because they relied on the type of evidence that we would expect them to rely on, despite the distasteful political views that the defendant is espousing, the deliberate, trying to railroad and grandstand at every opportunity. They used both that and the routine collection of evidence by the jail to show that he is competent. I would ask the court to adopt, for example, both the civil cases, the GR and the PR case numbers in which the defendant engaged in self-representation in a similar manner without any barriers to competence. Now, Dr. Loring is here today. I offered to call her to sort of underscore or highlight some of the things in the evaluations, and I would predict she would say nothing she has seen here today or at the last hearing would change her opinion.
Well, I'd like to hear from her.
Okay.
If he could say exactly what you believe she would say. Let's
Yes.
call her at this time.
Okay.
Dr. Loring, if you could please come forward.
All right, so one of the one of the doctors is going to testify. However, they kind of sprung it on our Nevada judges that to not not record any of the testimony here. So we're actually going to we're unfortunately skipping over this.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, I do.
You may have a seat. And before you state your name, and first of all, make yourself comfortable. Please slide in and bring the microphone in, Ben, pretty close. Before she starts testifying, the question. Do I seal this portion of the hearing because she may go into Mr. Hillygus' medical, physical, and mental health issues, and ask that the recording cease at this point and the transcript be sealed, because this is going into areas that might be considered otherwise private and not subject to public dissemination.
Yes.
What do you think, Mr. Prasad? Do you need a moment to discuss with Mr. Hillygus, or?
I think out of an abundance of caution, it should be sealed. I think it's likely she's going to go into some of those factors.
Just to protect Mr. Hillygus and make sure that information that might be disclosed here doesn't get out into the public. Mr. Hillygus, you want to say something?
I just want to place on the record that there is an investigation by the DOJ for HIPAA violations, so anything.
Hey, Taco, thank you for being a member for 26 months. I should play the Final Fantasy 16 demo, maybe Cup of Tea, God of War, and Assassin's Creed if you're doing well. I appreciate it, Taco. I mean, look, I might take a look at the demo. I don't have high hopes. I haven't touched a Final Fantasy game in a very long time. I fell out of it, but I don't know. I might check out the demo.
This ordinance states can be used against her.
All right, thank you. The court orders that this portion of the hearing be sealed. The minutes shall not be filed other than under sealed level of security or further order of the court. The court asks those that are currently videoing this hearing, please stop at this time, and then we'll resume when this witness is done testifying. Mr. Stagey, anything else you'd like the court to, your view, your approach, your suggestion?
Carl, thank you for the 5 gifted memberships.
I'd ask you to find.
I appreciate it.
Thank you. Anything else from you, Mr. Prasad?
I have nothing further to add, thank you.
All right, thank you. Give me just a moment, please. The court finds that Mr. Hillygus does possess the ability to comprehend the nature of the criminal charges against him, that he understands the nature and purpose of the proceedings against him, and that he can aid and assist himself within a reasonable degree of rational understanding throughout the adjudication process. Furthermore, in the event the court were to appoint counsel or Mr. Hillygus change his mind and hire counsel, he could assist that person during this process. So, Mr. Hillygus, the court does find that you are competent to proceed to adjudication.
Goddess, thank you for becoming a member.
Spend a couple minutes going through the what happens now. I gave a preview of what might happen, what issues might be in play, but now it gets more direct. The first thing is I order the Washington County Sheriff to please release your arm restraints so you can take notes a little bit easier, Deputy, unless there's a public health or safety reason you can think of. All right.
I think actually this was around the time where I turned off the premiere, so I actually don't know a whole lot about what's going to happen from here on out.
Judge, I'm only gonna release his right hand.
Are you right-handed, sir?
Yes.
All right. For now, that'll work for today. Going forward, it may be both, particularly if you're sitting by yourself. Next, the court relieves the Washoe County Public Defender's Office of the appointed counsel for purposes of the competency hearing, because that hearing and that process has now ended with a decision by the court that Mr. Hillygus is competent to proceed. With respect to standby counsel, if I relieve the Washington County Public Defender of their role as standby counsel, there are a couple issues there. One is that if Mr. Hillygus later were to determine he could use their advice and assistance and be a resource to sit there and help answer questions, they won't be there. There'll be an empty chair there. Or if we go to trial, there'll be a co-defendant and co-defendant's counsel there. The other issue is I really want to make sure Mr. Hillygus has easy access to file things and review things that are filed promptly. And it certainly would assist the court to have standby counsel there to fulfill that role. But I realize that's not generally what standby counsel is used for. Not a sort of a glorified file clerk. You need to have another approach. Mr.
Of course,
Prasad,
Eddie.
Thoughts on, you can see the court really wants to thank very much the assistance you've given to this point in your office, and excuse you from any further role. On the other hand, I'm just wrestling with the idea that I want to make sure that Mr. Hillygus has the opportunity, because he's in custody. And if he were out of custody, it would probably be a little bit of a different analysis. But he's in custody, which means he only has so much time out of his cell or his block, or so much access to the law library, or so much access to do things that people at liberty would otherwise have to do. So any thoughts there? And then I'll hear from Mr. Stagey, then I'll hear from Mr. Hillygus. Go ahead, sir.
Thank you, Your Honor. With respect to, I believe the court's concern is to do with the filing. As I think was laid out in our memorandum, even if as appointed by standby counsel, all we can do as standby counsel is offer advice. We cannot participate in the filings that Mr. Hillygus wants to make, for, I think, the reason we made pretty clear in that memorandum.
Yeah, that's not really a standby counsel's role, is it?
Yeah,
Yeah.
and that's the issue, I think, regardless if you appoint us to standby counsel to serve as an advisory role or relieve us, Mr. Hillygus will still face, those same needs to file from the jail. That's not saying that it's an impossible task. I think he has provided with me with many documents that have not been filed, given that it's been a standby counsel solely for the purpose of the competency proceedings, which I made clear to Mr. Hillygus, and the court knows, so those are not filed, but I'm aware there were extensive documents. I'm confident if given away, Mr. Hillygus would be able to get those filed to the court without the assistance of myself, which I cannot provide anyway. You can ask standby counsel to get those.
So your view would be that your role would end today?
I believe Mr. Hillygus has made it very clear where he stands on the
Okay.
continued participation of my office. in
All
this
right,
case.
please have a seat. Let me hear from Mr.
Of course, Hillygus wants nothing to do with those bar members, those foreign aligned nationals.
Mr. Steggy. So, Mr. Hillygus, what your counsel wants, what I think you want, is for the court to excuse Mr. Prasad, the Washington County Public Defender's Office, from any further involvement in this case on your behalf. Is that what you'd like the court to do?
That's correct. They have not really provided much assistance at all. Like I said, I've asked for witnesses to be subpoenaed to this hearing. I've asked for evidence subpoenaed to Tecum. In fact, there's so much evidence that's being withheld by the prosecutor's office.
We're at pre-trial, buddy. We're in pre-trial.
I filed what's called a writ of cert.
Hold on one second. Let's stay on track, though. If you're going to tell me all the reasons why there should not be a claim, while there's no victim, while there's no
That's not, I'm talking about the exculpatory evidence that's being withheld up to this case, up to this point.
We might get there in a minute or two, but right now, the question is, does the court thank and excuse Mr. Prasad?
I've asked him to also subpoena the information from Missouri where I was unlawfully detained. And so he has not been any help to me. So I do not need their.
I've actually kind of drawn a blank about this situation in Missouri. I've only understood him taking his, again, I keep forgetting whether it's his mother or grandmother, out from a home in Nevada out to California and then getting arrested and extradited from California back to Nevada. I don't know what's going on here with Missouri. Hey, I see out of our Nevada judges in the chat. Everybody go check him out. It's a great channel, a great educational channel. They're doing great work out there in Nevada in covering really good cases, but also ensuring that the courts are open and transparent to the public at large. So guys, check them out for sure. And Goddess, thank you for the $20 tip. I really appreciate it for the kitties. Thank you very much.
Assistance, they're not really assisting me at all.
Okay, then understood. Mr. Steggy, anything you'd like to add on that issue?
Just, I find myself in agreement with Mr. Prasad, given, I think, the law on this would be concerned about doing violence to the defendant's desire to represent himself, sort of forcing him to have standby counsel. The court's concerned about... So
people in the chat are saying that I guess while he was out on bond or something, he went out to Missouri and then they hooked him up there. Gotcha.
Things, I think.
Manageable?
Oh, for sure. I mean, look at his history. I mean, he is a prolific e-filer historically, right? So
naturally,
that's an issue. The court's concern, and I'm happy to brief this issue. This issue of his access to the file or his file while in custody. I would suggest two things. One, we don't really know that much about it. I think we're presuming that he would have limited access. I think a hearing might be in order on that. I'm aware that the defendants have tablets in the jail, and Mr. Hillygus certainly would not be the first or an unusual per detained litigants.
Well,
So the sheriff has handled this before.
COVID era,
Yes.
that's new. We have somebody who left the community and then was brought back against his will, and he's now not at liberty. And we also have somebody who we have a trial date coming right down the track here.
Right.
So we have a lot going on that we have to make some decisions on pretty quickly.
Yes, to use the court's word, I think that's completely manageable by sheriff's staff at the jail. I mean, frankly put, he doesn't have a whole lot else to do but prepare for trial. I know also that, you know, since this case has developed, we're much more skilled at using electronic discovery. I mean, the entirety of this case is available in electronic form. So I would not want, nor would I suggest that the court is detained status and pro per status, that would be a cognizable barrier to self-representation or the.
Goddess, thank you for the $5. I imagine that a sovcit visited Missouri. Cue the dueling banjos.
Well, as to the first thing, the court agrees as to whether we're still looking at the August 27th trial, 28th trial date. We're going to talk about that shortly. All right, then without further ado, Mr. Prasad, you're excused from further involvement in this case. Thank you, and to your office for the work you've done to this point.
Prasad is like just... Christian Prasad is just like, hell yes. Thank you, Lord. I am out. And thank you, Anonymous, for $15 for Archer. Thank you very much, Anonymous. I appreciate it. Guys, I actually do appreciate the tips, because obviously YouTube doesn't take a 30% cut out of it. But so I do appreciate it. You know, you get so the tips go a long way towards helping out Archer.
So let's get our list of things.
But like I said, I don't need it
out so we can both be tracking at the same time.
I should be able to pay off all the bills even with this month's pay and everything like that.
I'll do my best to call on you if I would like your thoughts or insights on something, and if you have something else you want to address the court, let me know, and I'll often give you a chance to speak, or I might say, hold that thought, I'll get back to you in a minute, as I will with Mr. Stakey.
I'd like to object to Mr. Stagey's referencing me as a pro per, a self-represented.
Oh God, here we go.
I present myself as the living man. I do not represent the fiction. I am not a fiction. I'm not a corpse. I'm not a transmitting utility. I am the living man. I'm not pro per, pro se.
Okay, all right, you know what? If you have free man, free inhabitant, I'll let you count that with his natural living man thing.
I do not represent myself. I present myself as a living man. So I object to the use of the word pro per, pro se, self-represented litigant. That is not who I am. Thank you.
All right, well, let me respond to that, because you will hear both the court and Mr. Stakey throughout this trial refer to you interchangeably as self-represented litigant, pro per, pro se. We're not doing that to be disrespectful of your views, but because you want to be identified as somebody presenting yourself as opposed to self-represented, I understand your view. You do not have to reaffirm that every time we use that phrase. It's noted.
All right. Because this is not the first hearing that a judge has experienced with Hillygus. I have to feel like this judge actually genuinely has no idea about sovereign citizens. I think this is honestly his first approach. This is his first dealing with a sovereign citizen. And I would have hoped that after the first one or maybe two hearings, he may have wanted to do a little bit of research, or his law clerk may have wanted to do some research on what this guy's talking about. But the judge sounds completely ignorant of sovcit lingo. And Andrew, I did watch like like about half an hour's worth of that mess. I couldn't take it, but it sounds interesting though if I stuck through it with the Rise of the Moors motion from Jamal.
We're not going to change the way we refer to people. That's the way the statute read, the rules read.
I would object to the statutes.
Uh-oh.
Statutes and codes are
Statutes and code. Ah, there it is. Statutes and codes.
law under the Clearfield Doctrine, which is in Black's Law Dictionary.
Black's Law. Oh my God. Woo! Black's Law Dictionary. Thank you very much, Pope Phil the First, for the leet donation for Archer. Hope he feels better soon. Thank you very much, Pope Phil. I appreciate it, man. No, yeah, Andrew. I mean, I'll watch, especially when it comes to Jamal and the Rise of the Moors, because we haven't really had an update on them in a while. I tried listening to him. He's in. I don't want to get sidetracked, but I might end up actually talking about the his video in a future live stream because everything that he says is just typical nonsense.
Clearfield versus United States. Since governments have chosen to incorporate.
Oh, did he already say I do not consent? I don't even. I do have it.
They have to follow the same rules of corporations. So under the Clearfield Doctrine, this court lacks jurisdiction over me as a natural living man. I am not a fiction.
But you're repeating yourself now.
Well, I'm expressing the Clearfield Doctrine, which is in Black's Law Dictionary, Clearfield Trust versus United States. And I'm also expressing Self versus Ray and Donovan versus
Self versus Ray is an often misquoted case law, and Donovan is often the people every piece of literature, sovcit literature I've seen that tries to quote Donovan, the quotation is completely made up. It doesn't appear anywhere in the opinion.
Donovan versus Doan administration and
Yeah, it does. Yeah.
Rundell versus Delaware versus Rundell.
Link, did your tip go through? If you were one of the anonymous links, then yes.
I understand your position. Now, let's move forward. I was hoping we had representatives from the filing office here today in the event of a adjudication of competency, and also from the Washington County Sheriff. It doesn't look like we're going to stand up that type of a discussion today to make sure that Mr. Hillygus has access to whatever he needs to make filings in this case, review things promptly, essentially in real time, so that his custody staff does not work to his disadvantage. What I would like to do is set a hearing. Unfortunately, the court's not available next week, and then I'm in trial the following week, but I can set a hearing first thing in the morning, or actually 1 o'clock in the afternoon, July 6th, 1 in the afternoon, July 6th, where we can cover a couple things, including making sure that there are no technology or logistic impediments to Mr. Hillygus' status of being a defendant, representing himself or presenting himself while he's at the jail. Will July 6th at 1 o'clock work for the state?
No, Your Honor, I'll be
Throughout that week?
I'm out actually 2 weeks that first. So I would prefer perhaps if we could be at the end of a calendar, latter part of June, if that's available.
$11 o'clock Tuesday, June 27th. 11 o'clock Tuesday, June 27th, so 2 weeks or so from now.
I wanna shout out Link 219 for the $10 tip. I apologize for the mix-up. The tip went to my gaming channel, not to my corporate fiction channel, so I didn't get the notification. But I see it there. But thank you very much, Link, for the $10. I appreciate it, man.
So here's what I would hope to do. I'm in trial. I'm in trial, so I would tell the jury, go for an early lunch, and we would go through some things. One of them would be that I would direct the Washington County Sheriff's Office representative who has information, and that somebody from the filing office here, to have them come in and make sure that everything's working the way it's supposed to, so that Mr. Hillygus is not prejudiced by the fact that he's in custody while he's defending himself from serious criminal charges. So I will issue an order directing somebody to come from both of those entities to be able to speak on things like that. So one thing for you, Mr. Hillygus, is if there are any issues that you believe are working to your disadvantage with the way you're having access to information, computers, tablet, filing office, be prepared to address them when I see you on June 27th at 11 o'clock. Okay, that's number one. Number two, if you want the court to take another look at your custody status, I looked at it recently, but if you're asking the court to take another look at it, you need to file a request, file a motion. Call it motion to change custody status and put in there, good cause. And if you're gonna say, Judge, I'll be in Texas, you don't even waste your time. I'm not gonna allow that. I need you to be living somewhere in Washington County.
That's right.
Agree, even if you don't like it, that you're gonna have to wear something that tracks where you are, tracks your movement, even if you don't like it, and you're gonna have to pay for that. And then we're gonna have to talk about what a reasonable bail would be. So if you can make a persuasive argument to the court that you can check those three boxes, somewhere in Washington County, have a GPS monitor and reasonable bail, the court will take another look at it. Because if you just say, Judge, you don't have any right to keep me in the jail, you're just gonna be wasting your time.
Well, I would object that that's punishment, and I have not been convicted of a crime. For you to put me on house arrest is punishment. To put me on a tracking monitor is also.
Oh my God, he's doing the Blandino thing. He's pulling a Blandino, where the conditions of release are preemptive punishment.
Punishment is unconstitutional. And as one of the people, I'm standing on my constitutional rights. And I will tell you that there's so much exculpatory evidence that the prosecutor, I don't have any discovery. And the prosecutor
Well, we're gonna talk about that.
so much evidence in this case that this case should be dismissed immediately.
Okay, let's just stay on the track though. If you want me to change your custody status, that's what I would be looking for. Mr. Steggy, do you want to talk about that issue?
Only, I wish the court would not keep coming back to this. I mean, the law says there has to be a change in circumstances. This is no change in circumstances. The law is clear, you don't get special privileges if you're self-represented in jail. I would not like it to be the case that because he's now self-represented, he would have more of an option to be released.
He has no more nor less. What I will do is just remind him what the court's concerns were.
Thank you, Woodwork Learner, for the $6.90 tip. I don't understand these dollar things. Well, you're figuring them out tonight.
At our last hearing, and if there's a change of approach or ability or resources between that last hearing and sometime here before trial, I'll take another look at it. So let's move on. I've already told you, Mr. Hillygus, if this matter goes to trial, and if you need to be in a wheelchair, you're gonna have to let the court know, Mr. Steggy know, and we'll have a hearing outside the jury as to what the medical need is. Without that hearing and that permission, you're not to appear in court in a wheelchair. Again, I'm not picking on you, that's how the court rolls in civil matters and criminal justice matters. It's not a Roger Hillygus matter, right? Now, you mentioned discovery. So what is the status, please, of the discovery that the state otherwise would be required to produce to defense counsel? What's your understanding, Mr. Steggy, of where we are in that, and what, if anything, is still owed to Mr. Hillygus?
So,
Hey, bottle cap.
In justice court, full discovery was provided through Mr. Hillygus' counsel. After he became self-represented, we made available to him a number of thumb drives containing discovery. Given the defendant's known history, we both emailed him and mailed him saying, please come to the DA's office to pick up this discovery. That those thumb drives now have dust on them because the defendant never availed himself of
Well, now he can't, so how do we get it to him promptly at this point?
Quite easily. Because he is an e-filer, his email address is known and he is served by in eFlex to his email address. We now can deliver discovery to an email address. So shortly, that will happen. Now, to avoid any games that this case has been plagued with from the defendant, I would ask that he, before the court, tell you his email address so that we can avoid any shenanigans related to this.
Well, you need his email address and his eFlex. Well, if you file something with eFlex, if he has an eFlex account, he
Yes.
gets it, right?
Yes.
But you want to send him things that are not fileable. You want to just, like,
Yes.
if he were in person, you'd hand it to him, or he could come to your office.
Yes, for example, if we had any private defense counsel in here, we currently send them a link to discovery to their email address. Now, I know that he has eFlex, and I've heard him complain on jail calls about eFlex. So rather than just, and I suspect it's the same email address, but I want him right now to affirm to this court what his email address to, or ask that the court do that. If not, I'll just send it to the email address that's on file with eFlex.
So I think what the prosecutor's trying to say, I want Hillygus to put on record his email address such that if Hillygus says, I never got my discovery, the state can provide proof, like a sent or delivery receipt, showing, hey, here's my email. Here's the email address we sent it to. It's the exact same email address that he said in open court. So there's no way that he did not receive the discovery through that email address. I think that's pretty much what the state's trying to do here.
And if he says he doesn't have it, this is the moment where he has the opportunity to tell me or you the true email address.
Well, so the idea is that they want to get this to you right away.
I object to everything he's saying. I'm asking for a paper copy printout of every piece of discovery that they have, because it keeps changing. It's changed over the last 4 years. Every time they realize that they're withholding evidence and I'm calling them out on it, they decide to give a little piece of evidence. It's changed so much. There's still so much evidence that they're withholding. Those are criminal acts. They're withholding evidence, they're tampering with evidence, they're tampering with witnesses, and
Well,
I need a paper printout of the copy. I don't have access to a computer. I don't have access to a law library. I don't have access to email. I don't have access to everything that he's saying, thumb drives. If he wants to provide me the discovery, they need to print the discovery out and provide it to me where I'm at. I'm in a cell. I'm in the cell 22 hours a day. I do not have access to a computer. I do not have access to a law library. I do not have access to a printer or a typewriter or any kind of way to do research. So I'm asking them to provide a printout of the discovery because it keeps changing, and it's changed over the last 4 years.
Well, some of it I'm going to assume is not printable. Some of it is audio or videotape. Is that right, Mr. Steggy?
Yes, and I'm grateful for my use of the term shenanigans, because you've done right to a shenanigan. There's no, our statutes on discovery don't entitle him to paper versus any other form. He has the right to inspect and copy the discovery. This is superior to any method. And so.
Superior to any method?
Well, the idea that, so we give him paper, he's gonna engage in shenanigans saying I didn't get all the paper. We know it's in the court record that he has access to email, because I showed in my motion, my second motion for gag order, that these Nazi-themed missives that he's sending are coming from an email.
What? Wait. What? What themed missives?
Through email correspondence between him and others. So email is the perfect format for discovery to occur. And I do not believe it would be appropriate for the court to dictate which that paper be given rather than electronic copies.
Well, here's the way I'm intending to handle this. The way I'm intending to handle this is to make sure that you have a tablet, computer access, law library access, and the ability to prepare for this trial. If there are issues remaining, when I see you in 2 weeks, and judge, whatever you've ordered isn't working, I'll look at making the district attorney's office print out every piece of paper that the law otherwise would require them to produce to you, and have it hand delivered up to the jail. But I'm gonna let 2 weeks work to see if the email method works and the eFlex method works, because that is no different than what somebody who's not representing themselves or presenting themselves would have.
I do not have access to eFlex, I do not have access to my internet, I do not have access to my email. I'm in a cell 22 hours a day without access to a law library.
Well, here's the reality. Let's suppose
no
that
internet, no computer,
if you
nothing.
convince the court of that, if you convince the court of that.
So you're saying 2 weeks of the same? So I'm not getting out to go to a law library, I'm not getting out to have access to a
Well, hold on. I would say
computer,
2 weeks of the same.
keyboard.
I'm going to assume the Washington County Sheriff's Office, I'll issue an order that the Washington County Sheriff's Office knows. Either they know right now because we have deputies here, or they'll know by the time, the next day or two when I get an order out, that you're representing yourself, that you're presenting yourself, and that I'm expecting them within, safety for you and others up there themselves to make sure you have resources available to review information, send emails, and make filings.
all day long, not just for an hour.
That's not gonna be all day long, but it's gonna be for more,
My
obviously.
waking hours?
I'm gonna review some of the other approaches used in cases like this and come up with a reasonable.
No, they're not going to allow. They're not going to allow you to hang out at the law library for 9 hours a day, or 10 hours a day, or 12 hours a day. I'm pretty sure most, if not all, major prisons have law libraries within them. It just doesn't mean that you have full-on access to them 24/7 or even for like 12 hours a day. I doubt that's the case, even if you're a pro se, you're operating pro se.
A printer, a computer, a
I
laptop,
understand.
internet, so I can do research.
Most prisoners do have access to the computer, but again, it's extremely limited.
I can
got it,
access
but-
my email, I can't access my email, I cannot access eFlex
Well,
without a laptop.
Carl, thank you for the $5. Already. Oh, you know what? I think Carl or you or somebody else asked this question on Monday and I completely forgot. What's your opinion on the child predator catcher YouTube channels and how they're being removed from the platform? I don't know anything about them being removed from the platform, but if you want my honest opinion about the vast majority of them, like most of them, they're clickbait. They don't do anything, because in the vast majority of these channels' cases, any evidence that they have can't be used against the alleged predator. I think there's maybe one, maybe two channels. Well, I think I know only of at least one channel who actively works with law enforcement, and it's actually a channel that runs around here in New Jersey. But the vast majority of these other channels are do nothing but clickbait, because they don't nothing happens from it. Because the police can't use what they have as evidence.
Without a printer, without paper to do my research.
Mr. Steggy, yeah.
I would suggest that a review of the law on this subject would be helpful. You know, I'm confident, and I'll try to prepare a bench memo for the court on this issue, but this isn't doesn't turn into a Burger King situation where you get whatever you want, right? Where the jail has to bend over.
Have it your way.
Backwards, that the court has to order special accommodations because the jail is used to it.
Let me just say this. Here's my.
I haven't heard any of that,
Reasonable
Goddess.
access in order to properly defend himself.
I agree.
Okay, reasonable access. Is that a clear line? No. Does it mean he has the ability to file things? Yes. The ability to access a computer and do internet research? Yes. Access to law library? Yes. But he also has to make sure he can access his email, and because the district attorney will serve things, distribute things to defense counsel that way. So, but right now I'm hearing from Mr. Hillygus that is limited or non-existent on many things. So we're gonna make sure that doesn't become an impediment to his reasonable ability to defend himself. But we're gonna drill down on it when I see you in 2 weeks and 1 day. Between now and then, I just have other matters I'm gonna have to do. I'm gonna order this, Mr. Hillygus, that you make sure that if you're not comfortable stating this on the record, in open court and having this possibly played on the internet later, what your email address is, you can do, if you want to, tell us what it is. If not, when I go off the bench, I'm gonna have you, I order that you tell Mr. Stiggy what it is.
He has it.
Okay, well.
It's through eFlex.
No,
It's the email that's used on eFlex. He has it. It's the same email that they use on eFlex. It's sending me. It's my email. He's got it.
well, do you know off the top of your head what it is, Mr. Steggy? Could you identify it? And I'll ask Mr. Hillygus, is that the email he's referring to?
I'm getting to it.
Okay.
The state wants it on the record to make sure that Hillygus can't turn around and say, well, I never got the email.
Well, he's doing that. Let's go forward because we have more to talk about here.
Will it work? I have no idea.
HILLYGUS@gmail.com.
All right, is that the one you're using, sir?
Yep.
Okay, so we're good.
Hmm.
Oh, speaking of grounds.
So let's talk about this June 27th hearing we're gonna have in 2 weeks to make sure that you're having reasonable access.
Speaking of grounds, I'd like to, I guess, thank Blue Bacon for this random gift that he sent me. Because you know what? I don't have enough coffee mugs. So why not?
To technology and information to be able to defend yourself. If you believe that you're gonna need a trial postponement because trial is currently set for Monday, August 28th. I wanna hear if you're in a position by June 27th to know whether you're seeking a postponement to tell us. You can tell us on the record. You can file a motion, but if you know on the record by that time, you can tell us, Judge, yes, I'm gonna need a postponement. Or Judge, I'm gonna be filing a motion later today. Or Judge, I filed a motion yesterday and for the good cause reasons. Mr. Hillygus, listen, I realize it's June and the trial is at the end of August. I know that's a short period of time. And we're not gonna do things that, because of the competency hearing and the delay, it's gonna work to your disadvantage. Now, I know Mr. Steggy's gonna say a lot of the delay was,
It's self-inflicted, yes.
imposed here by your actions. I'm beyond that right now. I wanna make sure you have enough time to prepare. So give some thought to whether you're gonna be asking for a postponement. You don't have to tell me now. You can give it more thought.
I keep wanting to go back to this court lacks jurisdiction, and there's all kinds of
Well,
exculpatory
we're gonna have a
evidence.
hearing.
Stop! Oh my god, this judge is frustrating the hell out of me. I can't deal with this judge.
We're gonna
This
hear-
case should be dismissed, Your Honor. You've got plenty of information in front of you that I have not committed a crime. There's no crimes committed here. There is no victim, and there's all kinds of exculpatory evidence, which includes a writ of cert filed with the United States Supreme Court naming Amos Steggy and Christopher Hicks as perpetrators on RICO. And there's also right now
Rico! Oh, I feel like Rico needs to be on the list too. Oh, Rico.
a FOIA request. The federal government is looking into why I was unlawfully taken in LA and in Missouri under a Fourth Amendment violation, which is an illegal search and seizure without proper documentation for a search warrant or an arrest warrant.
Well, okay,
So when that FOIA comes through, it's gonna be federal.
well,
FOIA and everybody.
here's my take on it.
And the investigation that's happening right now with the for-profit corporation known as the Washoe County Detention Facility and the Washoe County Sheriff's Office, for-profit corporations run by Mark Bello and Darren Balaam. They are under investigation for ADA violations and for HIPAA violations, and for Fourth Amendment violations, illegal search and seizure. And the United States, or the Nevada Supreme Court ruled in Mack back in December that anybody that does an illegal search and seizure loses any immunity, and they are personally liable and responsible. So that's what's being investigated right now. And so if there needs to be a continuance, I'm not asking for a continuance. I'm asking for this case to be dismissed. I'm asking to be released
Of course he is.
because I'm being unlawfully held and detained. Thank you.
Trial's at the end of August. Right now, you're like, that's great, but Judge, I'm gonna be filing motions that are gonna lead to this case being dismissed, so there's never gonna be a trial. I get that.
I object. I don't file motions.
What do you do then?
I file notices and demand.
That's another classic sovcit thing. I don't file motions, I file notices and demands. That's another sovcit shtick. Because, you know, you're because I think the emphasis is that because you're the sovereign, you are above everybody, right? You're above all these public servants. You don't make motions, you make demands of your public servants. You make notices because you are that's the whole that's the whole premise behind them saying they don't do motions.
Because this is I'm proceeding under the common law and the NRS 1.030, the common law. I am one of the people, and that's how I've expressed my status and my standing. I stand on the Constitution, and on my status as a natural flesh and blood living man.
Do you stand under?
Court, I'm opening up a court of competent jurisdiction, and you lack jurisdiction in this matter. So this case shall be dismissed with a notice to dismiss.
This case shall be dismissed? Oh man, the chutzpah on this guy. Shall be dismissed.
Because you lack jurisdiction, and when that, I will get that to you as soon as I get it from Mr. Prasad.
Take that. Got him.
Let me just finish the thought, and I'm gonna move to another subject. In the event there are pending motions that have not been decided, the court will hear them and make decisions on them, hopefully from the bench on July 27th at the pretrial conference, if the case is still pending at that time. I'm not at this point gonna take time and discuss any further things like voir dire, jury instructions, marking
Wadaya?
exhibits. If and when, we'll have a discussion on that at a later time. Custody status, I've already referred to. Technology at trial, we can deal with that later. Subpoenas for trial, we'll deal with that later. Hearing on cameras in the courtroom for any trial, I've told you that's an issue. We'll firm that up later if we get to the point where that trial is coming down the pike. close by. Standby counsel has been relieved of their obligation and their appointment for competency proceedings only. Mr. Hillygus, I just remind you, you're not to contact Mr. Hanty without going through Mr. Silverberg and making sure.
Hanty is the co-defendant. He is the former sheriff who aided in the alleged kidnapping.
You reach out to him before you attempt any direct or indirect contact to Mr. Hanty. It's because he is his counsel, you have to go through him. The gag order motion that the state has previously filed, the court will set that for a hearing, and the motion to strike the 2 pleadings, the court will set that for a hearing. Whatever else you're going to file, if the court believes a hearing would benefit the court's analysis, I'll set it for a hearing as well. Mr. Steggy, the court orders the Washington County District Attorney's Office to promptly email the discovery that you previously were going to make available at your office to counsel, to Mr. Hillygus at the email that you have that he's confirmed the accuracy of. We'll take up at the hearing in 2 weeks and 1 day if this is working or if there are other things that the court needs to order. And the court does anticipate entering an order shortly, directing the filing office and notifying the Washington County Sheriff and the filing office of Mr. Hillygus' self-represented or self-presented status, and to make sure he has reasonable access to do things he needs in order to prepare for hearings and trial. I've already indicated that when he's in court, he can have his writing arm free, and if he's sitting there alone at table, he can have both arms free. All right, that's really all I wanted to do today. I have to get to some other things that the court has to handle. Mr. Steggy, I'll hear from you if the court overlooked anything or any final thoughts, and I'll hear after that by Mr. Hillygus.
No, thank you.
Mr. Hillygus, anything else for the good of the order here?
I would like to make a record that
I like to make a record. The spirit of Blandino is alive and well.
the exculpatory evidence which is missing is a writ of habeas corpus filed in federal court regarding my mother, multiple Nevada appeals, the civil record, the whole record, the federal lawsuit that was filed for racketeering in the...
Yes, I'll count that as for the record. He said make a record, I'll count that as for the record.
And it was taken up to the United States Supreme Court as a writ of cert. I'd like that writ of cert. The Division of Financial Institutions, which was presented with a complaint that was investigated regarding the facility where my mother was being abused and neglected. The Nevada Attorney General has a complaint as well. The Nevada Ombudsman investigated the institution and found that they were deficient. My mother was hospitalized. We don't have anything from Stone Valley. The responding officer, Timothy Avila, on his body cam, is reading a protection order that was filed by me to protect my mother. That has not been presented as evidence. Nothing from Stone Valley has been presented as evidence. Her whole 3-year case file, all of her hospitalizations unnecessarily, all the medication that she was taking unnecessarily. This is just a thumbnail sketch of the exculpatory evidence that they're withholding. Their job is to look at a case and decide if they have reason to bring it forward. They have no reason to bring this forward. I have not committed a crime against my mother, against anybody. There's plenty of exculpatory evidence that will exonerate this case that's being withheld. I ask that that be investigated and brought forward, and they can dismiss the case. Thank you for letting me make a record.
Okay. I'm not going to order the state to disclose, not disclose at this point. If later you believe that there is exculpatory evidence that the law otherwise required to be produced, you're going to have to file a motion, identify what it is, the state can respond, and I'll make a decision. That's how that works. If you think it's, I don't know what Mr. Steggy's response is or will be to what he's just heard or otherwise, but it's not the kind of thing we do at a hearing like this. All right, with that, I want to thank everyone for their time and attention today. I'll see you in 2 weeks and a day. Until then, the court's in recess, and you can expect a short order coming out with respect to reasonable access for Mr. Hillygus to have resources to defend himself. Court's in recess, everyone. Thank you.
All rise.
Yeah, there we go. We're finally done. But we'll see we'll see him again in 2 weeks, it sounds like. But I do agree, I need a palate cleanser after that mess. So what better way of then to look at Dummy Kruger? Dummy Kruger's latest. How about that? It's a short one. Only about 8 minutes. I'm actually surprised nobody got a bingo either.
Welcome to the Dummy Kruger channel, everyone. Today's video takes place at a Circle K gas station located in Tucson, Arizona, where we will be following an auditor and cop watcher that goes by the name Tucson Toe Tag, which, if I'm speaking frankly, is quite bleak even for this group of faux freedom fighters. So Mr. Toe Tag here has an interesting YouTube channel, insofar as he used to be quite an active poster, but hasn't put out a video for 8 months. Well, upon his grand re-entry back into the cop watching scene, he is immediately arrested within about 10 minutes. Way to
Awesome.
go, Toe Tag.
Hi.
Get out of my way. I'm parking behind the motorcycle. Move your car. Move yourself. Put yourself out of the way. You're interfering right now.
What? Really?
I'm not going there. I'm going behind this light. Chill out. Yeah, I don't need to chill out. Move back. You're interfering right now. You understand that? You're keeping me in the road. I need to be behind his bike. Traffic man, when you can start a unit over here, please, to 2 North Freeway. You're not going to move? I'm telling you, I need you out of my way, and you're interfering. And you're on private property, so why don't you get on the sidewalk? All right.
So Toe Tag did move approximately 2 feet, so the officer's under the impression he'll now be able to pull behind the police motorcycle as he intended to.
Right.
I have a different angle that I'll be showing in a moment that will show exactly the location he moved to. This is an important piece because Toe Tag wrote on the title of his video, quote, "Arrested and cited after obeying." Well, we'll see about that.
Interesting. Oh my god, they're all over the... Oh god, they're all over the place. They're like locusts. Oh my god, there's even more! Oh, he's a Lions fan. Okay, that makes sense.
You feel powerful right now? Feel powerful right now? Does it make you feel powerful? Excuse me? Does it make you feel powerful? No, I just want to deal with this DUI. I don't want to deal with you guys. So why are you being a dick? Why don't you ask nicely? Why are you guys? I did ask. You pull up and get on your speaker and say, "Get out of the way." That's not being nice.
So that's of course Direct D, who now wants officers to, quote, "ask nicely."
Wait. Before Dummy Kruger says anything, isn't the whole shtick behind auditors is to be completely rude and jag-offs to police? saying I don't have to be nice. I can be rude. I have my rights. I'm an American, yada, yada, yada. Which they do. They do have the right to be rude. But, wait, well, cops can't be direct? Cops have to be the epitome of niceness? I don't know. I mean, cops should be professional. Let me put it that way. They should be professional at all times. But professional does not necessarily mean nice, right?
Hilariously coming from him of all people. Let's see what hurt Direct D's little feelings.
Oh, it is Direct D. Okay, yeah.
I'm parking behind the motorcycle. Move your car. Move yourself.
Oh, that was so mean, officer. But Toe Tag was standing right in the middle of the entrance/exit to this gas station. He was intentionally blocking the officer from getting out of the road to help with this DUI stop that was happening. Let's now check out a different angle. Just quickly notate where Toe Tag is standing. This has nothing to do with holding anyone accountable. It sure seems...
I know my First Amendment rights are being protected so hard here. I don't know. I'm on my knees basking and bowing to the auditors here, who are the silent guardians of my First Amendment by unnecessarily blocking a cruiser from engaging in a traffic stop. I feel so protected right now.
Looks like Grandpa may want to get arrested here.
Get out of my way. I'm parking behind the motorcycle. Move your car. Move yourself. Move your car. Move yourself out of the way. You're interfering right now. I'm not going there. I'm going behind your bike. You need to move out of my way so I can park there right now. Chill out, fat boy.
Oh. There's the niceness. Chill out, fat boy. Obviously courteous. Imagine having nothing better to do with your life than to be out in the middle of a week. I'm going to assume is a weekday, and unnecessarily cause problems.
Tony, I need you out of my way. You're interfering. Yeah, by the property, so I'll have to go inside.
As you can see in the video, the officer attempted to move around this man and may have even nudged his leg a little bit. The officer didn't want to arrest this man. It's clear. He gave him chances to move out of the middle of the damn entryway. But did that stop our faux freedom fighters from losing their collective minds?
I don't get it. I genuinely don't understand. It's not as if like, I don't know. I feel like to understand a civil rights movement, right? Of civil disobedience. I can conceive of that. I can understand that. But this ain't it. This is just baiting. This is pure baiting.
Hey, you better make sure you got PC and all kinds of shit. 'Cause this don't look good, bro. What are you doing? Do you want to go to court? That's what this turns into when you with us. I'm not fucking with you. That's what you're doing right now. That's what you're doing right now. You could have asked nicely. You don't get to roll up and start ordering questions. No, you don't. No, you don't. You don't get on your speaker. Sir, could you please move? I need to park right there. You wouldn't have moved. How do you know? You didn't drive. I sure did. No, you didn't. I got a report.
We all know damn well he wasn't going to move because that's the MO of these auditors. Isn't one of the primary MOs of these auditors is like, oh, is that a request? Then I will respectfully decline. Is that not like a common meme among these First Amendment auditors that when an officer actually asks somebody to do something, they say, I respectfully decline. Oh, it's Tucson. Yeah. I don't know what that means though, Brad.
Oh wow. Oh wow. Why you put your gloves on, man?
Okay.
Just in case you want to violate somebody's rights.
I ain't breaking the law, so if you touch me, be prepared. I'm gonna defend myself if I get unlawfully touched.
Oh, okay.
Snitch, where's your truck, buddy?
Do you have an emergency right now? You're only supposed to be using these lights for an emergency.
There's no emergency.
Oh, the Venn diagram is slowly but surely becoming a circle.
Read the Title 28 code. Yeah. You want to arrest me? I'd like to go to jail. You just did, you stupid.
I wouldn't have if you would have just listened to me.
You think that you're all powerful. If you would have said please nicely.
I did say please.
Kat in Virginia, thank you for the $5 tip. I appreciate it for Archer's Vet Care. Thank
Review
you.
the video and we'll see what you did. You don't get to get on your speaker and order people around. I'd have all over your car, taking a in your chest, dude.
Okay, settle down, dude. Yeah.
Yourself! Yourself! Piece of shit!
It's really obvious Direct D is playing a character here for his mind-numbingly foolish audience. He's
True.
admitted as much during court that he's simply playing this character because that's what the people watching him want to see. As for him boasting about fighting all of these arrests in court, yes, sometimes he does. Last fall, he
Also, he's a an abject liar. Direct D lies about the idea that somebody else owns and maintains this channel, even though at several instances he talks about how his full name, Christopher Ruff, is a YouTuber. He lies about the income that is generated from the channel in terms of him wanting to get be assigned counsel because he claims to be indigent, even though he's not. Oh, and when he gets assigned counsel, he doxes them whenever they don't do what he do any minute task that he asked for, or whenever they go astray, he doxes his own attorneys.
fought 4 of those and was convicted on 4 misdemeanor charges that included jail time. He appealed those convictions, but it looks as if that appeal has finally fallen flat. He has
Yes,
another
it
court
has.
appearance for those convictions on June 21st of this year for a sentencing hearing. More on that story as it unfolds. Alright guys, I think that's going to wrap it up today. If you'd like to see similar content,
He doxes them before they do anything. True.
consider subscribing, notifying, liking, and commenting below. This is Dummy Kruger, and I'll see you guys on the next video.
Yeah, Direct D on several occasions has been called out on being an abject liar to both the court and the public at large on the nature of his channel, his income, and what he does. I mean, for God's sakes, he still has the video up from his sentencing last October where he talks about how, I got a kid on the way. Please don't put me in prison. Please don't put me in jail. I got a kid on the way. And then in the same sentencing hearing, he says, "I'm gonna make $5,000 off of this video." Either I assume he's either thinking of the video that he's creating right then, or the video that he recorded when he got arrested. And then later on, in future engagements with the courts, he says, "I don't support nobody. I got nobody to support. I'm indigent. I got nothing. I got no money." And the court actually has called him out on this BS too. So he's on record as being a full-on liar. So it is what it is. Anyway, you love to see it when somebody who clearly doesn't have anything better to do with their life gets a comeuppance in the form of an unnecessary arrest. But, it is what it is. Thank you very much, guys. I want to thank you all for hanging out with me tonight. I'm gonna be no stream tomorrow. Either no stream tomorrow or probably on my gaming channel. I'm trying to revitalize my gaming channel for sure. But I'll probably see you guys on Friday. Thank you very much. Thank you so much, whoever you are, Anonymous, for the $500 super chat. I use beard oil, Carl, for the record, on the record. I just need to shave it. I gotta trim this bad boy. I really do. But I do use beard oil. Anyway, thank you guys again. Thank you so much for the tips. It really does help. It's really appreciated. Oh my God, this thing is a mess. It really does help. I really appreciate it. I do plan on using that care thingamabob for future medical needs. So I won't have to like hint at asking you guys for some assistance because I really don't. I really can't afford it. Don't get me wrong. I can afford it. It's just, I got to put off, some, future expenses, in the coming months. I was able to transfer some money that I had saved up for my, now canceled Japan trip, to help pay for it. So, it's been a rough couple of weeks, lots of things going on in the background. I know, Brad. I know that's what you meant, and we are. It's all good. It's all good, Brad. I promise. It really is. It's just things I got to work on. Sometimes it's just not the path you were hoping to take. Anyway, thank you guys again. I appreciate it. You have yourselves a good night. And yeah, take care. I appreciate it, guys. Adios.